Hi, good day and welcome back to the NLHA channel, where today we will be looking at the requirements for wanting to change the surname of a child. In the last couple of months, we've had at least 2 requests that came in relating to the change of a minor child's surname, where the two parents were no longer in a relationship, and what the process requirements were for changing a child's surname. I want to start off first and foremost by saying the following. If any of the parents, if you want to change your child's surname for any vindictive or vexatious reason, and it is not in the best interest of the child, but rather because of an issue or a dispute that you've got with your partner or your ex-partner, please stop. Please stop. Do not use your child as a pawn in any disputes or issues that you have with the other parent. I think it's very important that you take that into consideration when you want to change your child's surname, is the reason, the actual reason for the need or the want to change a minor child's surname. But before we get to the process, we first need to look at and consider what is prescribed in the law. And to do that, the first act that I want to look at is the Children's Act, and it's actually the only act that I am going to consider. In section 19, it clearly states that the biological mother of a child has full rights and responsibilities in terms of the child, unless it is otherwise decided by a court. For example, where the court makes an order giving the father full rights and responsibilities. We also need to consider section 21 of the Act, where the position of the father is taken into consideration. For example, when the father was married to the mother at a specific time, for example, at conception or at birth. And then there's also consideration given to unmarried fathers and when they acquire rights and responsibilities. So the effect of the Children's Act basically gives the mother, the biological mother, full rights and responsibilities automatically. However, the rights and responsibilities of fathers are conditional. Irrespective, the father's rights will always be considered when it concerns the changing of a child's surname. Another act that we need to look at is the Births and Death Registration Act. However, for the purpose of this video, I will not be going into the requirements of the Births and Death Registration Act. So the bottom line is, yes, you can change your child's surname, and the process of changing a child's surname will be as follows. Firstly, the change is done on application to the Director General of Home Affairs, the Department of Home Affairs. That is where the application, the first application or the initial application is lodged, is with the Director General of the Department of Home Affairs. Now, the Director General, they have strict requirements that they will consider before approving such an application. So it's not a question of just submitting an application and the Director General approves it. There are certain requirements that needs to be met, and they need to consider certain factors, as previously mentioned, before they will approve a application. However, step 2 is, should the Director General deny the application, or should the application fail, then it doesn't stop. The parents still have the option to then approach the court. For example, where the written consent of a father is required and the specific father denies the consent or denies providing consent, then the mother can make an application to the court to take a decision on the matter. And that is basically the only options that is available to a parent who wishes to change a child's surname. It's either through application to the Director General of the Department of Home Affairs, alternatively, if denied, an application to the court. It is therefore obvious that a child's surname can be changed through the 2 processes mentioned. However, what is important to note is the right to change a child's surname is given to both the mother and the father. And that in itself sometimes creates legal issues and legal complications, which one needs to be aware of. At the end of the day, the most important thing that either the Director General of Home Affairs or a court in that matter will consider is whether the changing of the child's surname will be in the best interest of that child. And if it is not in the best interest of the child, then unfortunately, I can assure you, you will fail in that application. Thank you for tuning in, and if you have any other legal questions, please do not hesitate to send us your request, and who knows, maybe we will answer your question in our next video or one of our next videos. Also, look back at our previous videos. Maybe you have an issue that we already addressed in one of our previous videos, and we thank you in advance for following this page and for liking, sharing, and also subscribing to our channel. Thank you very much, and until next time, goodbye.